Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at deadlines for applications under the EU settlement scheme and provisions for late applications and the Home Office guidance surrounding this. I'm recording this video in mid-May 2021, and the grace period that ends at the end of June 2021 is rapidly approaching. So I thought this is an important video to do. So I've shared my screen with you, and I'll put all the links below this video as usual. And where I'm starting is in Appendix A of Appendix EU, which is the definitions section. And this is the definition for required date. So it says this: A, where the applicant does not have indefinite leave to enter or remain or limited leave to enter or remain granted under this appendix. So if you haven't got leave under Appendix EU, the date of application must be before the 1st of July 2021, or where there's reasonable grounds for the failure to meet the deadline. Or, and then there are some other deadlines given for certain other scenarios, which we'll go through when we have a look at the policy. But the main principle from Appendix EU is the application must be before the 1st of July, or there is a provision for late applications where there are reasonable grounds for the failure to meet the deadline. Now, as we hit different difficulties with Appendix EU, and I think there'll be more of those and more of those before the court, it's always worth going back to the Withdrawal Agreement. So on your screen now is Article 18 of the Withdrawal Agreement, and Article 18(1)(d) says this. So this is where the provision for late applications comes from. It says this: where the deadline for submitting the application referred to in point B is not respected by the persons concerned, the competent authorities, that's the Home Office in this case, shall assess all the circumstances and reasons for not respecting the deadline, and shall allow, so it's couched in positive language, those persons to submit an application within a reasonable further period of time if there are reasonable grounds for the failure to respect the deadline. Notice that double use of reasonable there: reasonable period of time, reasonable grounds. So this is now dealt with in the Home Office's policy document. It's a chunky policy document, as you'll see from my screen there, 204 pages. It's the main Brexit policy document. EU settlement scheme, EU, other EEA and Swiss citizens and their family members. And this is version 11, published on the 6th of April 2021. As with all my videos, do check there hasn't been any updates when you're coming to make your application or consider this issue. So if we look down the content section, you'll see on page 26, there's this section, making an application deadline. So an application for indefinite leave to enter or remain or limited leave to enter or remain under Appendix EU must be made by the required date. And we looked at that definition in the definitions section of Appendix EU. Where the guidance refers to the required date, this means the deadline to apply to the EU settlement scheme as follows, as defined in Annex 1 to Appendix EU, which we looked at. Now, where the applicant has limited leave to enter or remain granted under Appendix EU, the deadline is before the date of the expiry of that leave, unless you are satisfied by information provided with the application that at the date of application, there are reasonable grounds for the person's failure to meet the deadline. And you'll see in each one I'm going to read to you, there is this reasonable grounds exception. So if you've got, say, pre-settled status, you've got that deadline to apply for settled status before the expiry of your leave, unless there's reasonable grounds. What are the other deadlines? Well, there are certain different deadlines, and in all other cases, you will see it's before the 1st of July 2021. So by the 30th of June, the end of the grace period, unless, of course, there are reasonable grounds. What are those other deadlines? Well, if you're joining a family member of a relevant sponsor, note definitions here, and that joining family member arrived in the UK on or after the 1st of April, 2021, the deadline is within 3 months of the date they arrived in the UK, unless reasonable grounds. If it's a spouse or civil partner of a Swiss citizen who arrived in the UK on or after 1st April 2021, within 3 months of the date of arrival and before 1st January 2026, unless reasonable grounds. In a case of a joining family member of a relevant sponsor and the joining family member is a child who is born or adopted in the UK on or after 1st April 2021, deadline 3 months of the date on which they were born or adopted, unless reasonable grounds. And then here we are, all other cases before 1st July 2021, so the end of the grace period. Now, there are certain cases where it is deemed that you have reasonable grounds for applying late. The two are this, where you've got limited leave to enter or remain granted under another part of the immigration rules or outside of the immigration rules, look at the first bullet point there on your screen, which hasn't lapsed, been cancelled or curtailed, etc. And the expiry of that leave is after the 1st of July 2021. The 1st of July 2021, the deadline is the expiry of your leave unless there's reasonable grounds. Or if somebody ceases to be exempt from immigration control, so they're exempt from immigration control and they cease to be exempt on or after 1st July 2021, the deadline is within 90 days of them ceasing to be exempt unless there are reasonable grounds. In all other cases, somebody can make an application and put forward their reasonable grounds. So these are the ones where there are deemed to be reasonable grounds. Other cases, you've got to put forward those reasonable grounds. Now, it says, in line with the Citizens' Rights Agreement, there remains scope indefinitely for a person eligible under the settlement scheme to make a late application where, in all the circumstances, there are reasonable grounds for the failure to meet the deadline. They must make a valid application and set out the reasons for missing the deadline. Again, as usual with Appendix EU, if there's issue and they're missing some of the components for the application to be valid, they should be prompted or contacted and given a reasonable opportunity to provide it. Then if it's a valid application, you go on to consider if there are reasonable grounds. And then here's an important part. In line with the general approach under the EU settlement scheme of looking to grant status rather than reasons for refuse, you must take a flexible and pragmatic approach to considering, in the light of the circumstances of each case, whether there are reasonable grounds for the person's failure to meet the deadline applicable to them under the EU settlement scheme. So it's going to be a generous approach, looking for reasons to grant rather than to refuse. Then there's guidance below which sets out some circumstances in which reasonable grounds may be shown, but it's not an exhaustive list and every case must be considered in the light of its particular circumstances. In general, the more time that has elapsed, the harder it will be to satisfy that there's reasonable grounds. And that goes back to the withdrawal agreement, that double use of reasonable period, reasonable grounds. And for the time being, following 30th June 2021, you will give applicants the benefit of the doubt. So that's really important if you're making this application or if you're a representative making representations in respect of it. You know, this is something you can refer to. The benefit of the doubt should be given in looking for whether there are reasonable grounds. And there's some dates about when applications for settled status will come up and talking about prompting people. And again, where somebody has not provided sufficient information in relation to the reasonable grounds, again, they should be contacted, engaged with, and given a reasonable opportunity, and discretion should be exercised in favor of the applicant to minimize administrative burdens. Again, so a positive approach. Where you're satisfied there are reasonable grounds, you're going to consider the application. it looks like where you've already made a late application, it's very unlikely you're going to be able to make, and you'll refuse, it's unlikely you're going to be able to make a second late application. But where it's deemed you haven't got reasonable grounds, it looks like you'll be refused under eligibility grounds, and then you'll be able to challenge that by administrative review or appeal. If somebody after the 1st of July is encountered by immigration enforcement, and because the grace period has ended, they're now unlawful in the UK, the immigration officer should consider whether they've got rights under Appendix EU or potentially, and give them 28 days to make that application under the settlement scheme. So that's helpful there. Then the guidance goes on to have a look at examples. So starting at page 31, we've got the examples, and in each one they set out the sort of scenario. They give some indication of the sort of evidence they look for and give some worked examples. So the first one is children, including children in care and care leavers. For example, say a parent or a carer has neglected to apply for somebody while they were a child, and now the child's an adult and they realize they need to apply to sort themselves out. That would usually constitute reasonable grounds. Again, I'm not going to read through the sort of different scenarios or the evidence provided. Interestingly, with that one, you do not need to consider the reasons why a parent or guardian or local authority failed to apply on behalf of the child, or the child did not make their own application. And then, as I said, examples are given. Physical or mental capacity issues or care support needs. These will usually constitute reasonable grounds. These are positive examples. And again, the sort of evidence that you'll need is set out there. And again, examples: serious medical condition or significant medical treatment was being received. And it includes pregnancy or maternity leave, or where a woman has had a difficult childbirth, or where their newborn child was in need of medical treatment. Victim of modern slavery. Even if they've just got a reasonable grounds, I think you'd be able to, a positive reasonable grounds decision, you'd be able to put that forward. Abusive or controlling relationship or situation that prevented somebody from applying. And then again, a sort of catch-all: other compelling, practical or compassionate reasons. And some examples are given there. So it's quite good and quite widely drafted guidance. Then we look at these two deemed situations where somebody's deemed to have reasonable grounds. So this is where they cease to be exempt from immigration control, and then, period of 90 days. An example is given, or without existing limited leave to enter or remain under another provision of the immigration rules or outside of the immigration rules. And then interestingly, where somebody had status under the EEA regulations and perhaps didn't realize they needed to apply because they thought they could just rely on their old EEA regulations documentation, that's provided. And even where somebody, it talks about somebody being able to gain permanent right of residence during the grace period under the old EEA regulations. Have a look at that. And if they waited to obtain their permanent right of residence and then chose to apply, and that was after the grace period, that would constitute, and an example is given. So helpful guidance there. So we've got some important deadlines coming up, and the primary one is the end of June. That's the end of the grace period. There are some different deadlines for other scenarios. And obviously we've got these reasonable grounds exceptions where late applications can be made, and some positive guidance, which is worth taking a look at. I hope that's helpful to you.